mention the ethical implications. As I said, when researchers came into the reading room, and that was the only way before we digitized materials largely, people, the archival professional is bound by a set of ethical standards. Anne was mentioning the balance between two goods. So we wanted to make sure people access these records, but that they did so responsibly, and that if we found materials that we didn't know we had, we could pull those. And it's this dual relationship of needing to be protective of the individuals reflected in the collections, but also providing access. And we do that through how we're educated and trained in how we provide materials. But that level of control is, again, often not possible through widespread digitization. I also want to say there's, when these records are originally created by physicians, they are bound also by ethics to protect privacy through the Hippocratic Oath. So this was a transfer of one custodian of records to another one that had very clear expectations and knowledge of privacy and how to do that. And this has become very murky now with new legislation as well as widespread digitization. So at this point, I'll hand it over to Anne again.
So one of the other game changers in this world of the historical health sciences collection, besides the internet and digitization, has been HIPAA. The HIPAA privacy rule pertains to covered entities and the covered part of hybrid entities, which usually in our world means that most academic medical centers are part of the covered entity, and in many cases the health sciences special collections find themselves part of that covered entity. At that point, they need to protect health information that involves a large set of individually identifiable pieces of information like phone numbers, facial photos, etc. And there are stringent requirements for use of the PHI in research. And there is no sunset date at present on this. So for example, if we have a collection by a doctor who was at the medical center in the 1950s, and we do, did a lot of work early with radiology. He gave us all kinds of things with all kinds of health information in it, and that information is protected by HIPAA forever and ever at this point. So many people who had, and institutions that had collections that say involved nursing or midwife notes or physician logbooks from maybe even the 18th century, suddenly found, wow, this stuff is really, really old, but now HIPAA is important for us, and we're having to deal with HIPAA. And if we digitize, we may be having to redact large amounts, and there was a real huge amount of concern amongst historians and archivists about this. And they, of course, alerted Congress, but I think the intention with HIPAA to cover and protect generations of health information won out. There was a desire to make sure that genetic information wasn't used against people, that health information wasn't used against people when they applied for insurance. And you know, some of these things have a sort of a long lifespan. So one of the things that we and other people who have the kinds of collections we have at Ohio State are dealing with some of these issues involving authorizations, waivers, and privacy boards or IRBs to allow these kinds of research to go forward. And of course, if you have people who all lived in the 19th century, most of them aren't alive anymore, and so they can't sign a waiver, they can't sign an authorization, but at that point we have to go to other authorities sometimes to make that information available for research purposes. One of the things that is a huge concern in this community is has HIPAA affected collecting patterns? Are people saying, I just can't take this because I can't deal with HIPAA? or I won't keep this anymore because I just can't deal with HIPAA, or I won't let anybody look at this because I just can't deal with HIPAA. And we think that that would be a real shame, that there is a lot of really interesting information and valuable information in these collections. And so, of course, one of our interests is in making these issues as comprehensible as possible to archivists and special collectors. Because when we start thinking about HIPAA, as most of you I'm sure know at this point, HIPAA is sort of the baseline for privacy in this area, but other confidentiality and privacy laws on the state level can provide more concern. And so that is something that we have begun to look at as well. You know, as you probably know, most states, Ohio and most other states, have physician-patient confidentiality laws. And as we digitize material in this area, the privacy torts take on some importance as well, with the sort of thing that Jasmine was talking about, especially. Of course, you know, when you're talking about older material, there are always statutes of limitations, so that gives us some protection in some area. An interesting subject is if there's a breach of privacy in this context, who is the person who committed the breach? And a lot of times, initially, at least, it was perhaps the physician. That may or may not provide much comfort to an organization. Libraries and archives are notoriously risk-averse, and understandably. One of the only cases we really have that deals with this issue involved the tobacco papers. And I don't know if any of you all remember the tobacco papers. Brown and Williamson Tobacco Company was involved in litigation in the 1990s, early 1990s, and a employee of their law firm who'd been going through a lot of records as part of getting ready for trial, realized that Brown and Williamson had known for a long time that nicotine is addictive, that tobacco can cause cancer, et cetera, and he became very angry and he began to copy the records that he was handling. And he amassed large amounts of very, very damning records and sent them to a number of people, including a anti-tobacco activist at UCSF, the University of California, San Francisco. And some of them were published through the New York Times. There was a big hullabaloo. And the library at UCSF ended up receiving all of these records. And they had this constant stream of visitors who were encamped all over the place looking at these documents. And they said, you know what? We're going to digitize these. And about that time, the internet sort of began to become a part of more and more people's lives, and so they put them online. And at that point, Brown and Williamson sued and lost, in part because UCSF hadn't committed the first wrong. There were several facets to the decision. They'd already been published. There was a public policy issue at stake, et cetera. But we, most of us don't want to go through that again, or ever. So we are still, even when we aren't dealing with HIPAA or dealing with state privacy and confidentiality laws, really grappling with the ethical concerns in a world where a lot of material can be digitized. And Judy will talk about this a little bit more, I believe, but one of the things that is a huge sort of push in this world is to just digitize everything. Let's just digitize it. And we really feel that in this context of the health sciences, it's probably not a good idea.
So we were looking at what do we need to do to make sure we're protected and what to do with our records in light of HIPAA. And one of the first points of decision to be made by anybody is to see whether or not we're a covered or non-covered entity, and whether HIPAA or HIPAA status applies to us. In many cases, the parent organization has already made that determined, and we need to look to the privacy officer to help determining this status. We at Ohio State are very lucky. We have a privacy officer who works with us through some of these issues and is interested. Other cases of this type of information in smaller collections or in small universities would look to legal counsel. One of the things that I think is important to do with special collections is to conduct a sensitivity audit before massively digitizing. I would not recommend, and we will not be massively digitizing things, even though that would make things a lot easier. Before you get to the point, and that's going from the reading room, where people were coming in to look at the tobacco papers, to throwing it on the world, because wouldn't it be just easiest if they just all stayed home and we didn't have lines in our reading room, can cause a lot of problems. So conducting a sensitivity audit, drilling down a little bit more to see what you really have and what you want to place online is very important, and it can identify materials that are subject to PHI concerns. Also, it is possible, though, one reason why you'd want to massively digitize materials is for preservation. Things are going to get handled, and the handling causes wear and tear on the materials, especially if you want to preserve them for long term. So even if you do a mass digitization project, we have been recommending in our research into our institution that you can massively digitize large amounts of records, but selectively make them available online. In this instance, you're looking at privacy and context, and this is using really the professional best judgment that we were told to use all along before legislation came in and mucked things up. I'm sorry, probably shouldn't say that, but you can really rely on why this is being used, what is the context, and really sharing that at the onset of a digitization or a mass sharing project. So the benefits of analyzing these issues are really to show the value of historical records, not that everything needs to be hidden or to be massively exposed. I think it's good to start this conversation because these records do have value. But I think the custodians and the legal counsel we're working with need to understand the legal and the ethical issues of providing such access to this. And then you can build a framework. So it's interesting. I always struggled with this before HIPAA. What should we be making? You know, they have these vague ethical guidelines. But I find that using the legislation can provide a framework so that you are confidently providing materials to people while respecting the privacy of those individuals reflected within the records. So thank you for giving us your time to